SJC-13315, Commonwealth v. Carlos Guardado.
Okay, Attorney Fraunhofer.
Thank you, Your Honors. May it please the Court. Elaine Fraunhofer for Carlos Guardado. This case involved two separate errors, a jury instruction trial error and the error that dictates the remedy required here, an insufficiency of the evidence, specifically the Commonwealth's failure to prove the element of lack of licensure. In its request for a different remedy, the Commonwealth makes two main claims. First, it argues that it was, quote, unjust for this court to permit the defendant to rely upon the clairvoyance exception, but not give that same benefit to the government. I have two responses to that. Number one, the clairvoyance exception pertains to the standard of review, not the remedy for the constitutional error that occurred in this case, the insufficiency of the evidence.
Can I ask you a question about that? You've said now twice that it's insufficiency of the evidence, and I see that that's how you have argued it in your brief. Why is that the correct rubric under which to examine this claim of error, when in fact the law was contrary prior to our decision in that case?
Because, Your Honors, the due process clause requires that the government prove its case.
Right, but it's not really a sufficiency of the evidence. It's not like the government knew that it had to prove that element of the case, that, you know, did everything it could to muster up the evidence. Instead, it's really more like, oh, here's a new thing. You have to now show that the sky is blue, and you didn't do that. Why is sufficiency of the evidence the right rubric?
As this court said in Beale, it is because the court is required to apply that law. It doesn't have the...
But in Beale, there was one bite at the apple. So in Beale, there was two ways to prove the crime, and Commonwealth chose one way, and we said it was unconstitutional to follow the federal law. But the Commonwealth had open to it the other avenue and chose not to. So they had a bite at the apple in Beale. Mm-hmm. Here, they didn't have a bite at the apple.
Well, I don't think that's exactly true. As I argued in my brief, the statute that they were prosecuting is unlawful possession without a license.
But we said in Gauss, we said you don't, I mean, we're very clear in our precedent that that's not an element, that that wasn't an element, right?
Well, that's true, but
this court said it, told everybody, yeah. Don't do this.
Well, you didn't say don't do this. You said you don't have to. You said that, but the Constitution requires it, and it's the Constitution that trumps.
Right, and the Constitution requires it post-Bruin.
I guess I disagree with that. And just like the Constitution didn't require post, sorry.
Because Gauss says that Heller and McDonald did not require it, right?
That's what Gauss said.
Right.
But it was incorrect. But it was incorrect. And the court said in Bruin that the interpretation of that this was required under the Second Amendment didn't just occur when Bruin was decided or when Guardado was decided. It occurred at least back when Heller was decided. In Bruin, the court said, courts are misinterpreting this. We have never limited this to only possession in the home. We are here reiterating what the Second Amendment protects. And so that right existed at the time of Mr. Guardado's trial. And so the fact that the government, decided not to put that in, and they did decide not to put it in. They said it would be easy for us to do so, and in other cases they did put that evidence in. If they claim they have that evidence, it was a decision they made. And I guess I just want to fall back to Justice Wendlett's point. I can understand the frustration of prosecutors in this case saying, well, we didn't know, we were told, but the fact of the matter is their frustration cannot trump Fifth Amendment and 14th Amendment law.
So we should be reversing then, or allowing new trials, and how many years are we going back? Under your theory, if the law was as it was before Bruin just clarified it, I take it all these cases need to be reversed?
It's up to your honors to decide
well,
what
it's
to
not
do
up
with it, but you're, in the Guardado decision, you said that Guardado would apply to cases on appeal, as I understood.
Your decision, I think what we're trying to ask you is, because of the Bruin decision, and it says it goes back to the founding fathers under Justice Thomas, we'd have to basically grant a new trial to anybody who's alive, right?
I mean, that is an argument. It doesn't apply in my case, but it's an argument to be made. But clearly it applies in this case.
But the rule I just want to make sure I understand the rule you're saying. Because again, this is not, ultimately this is the U.S. Supreme Court's decision as much as ours, right? So if Bruin is just a clarification and not a change of the law, are you saying that all the cases in which we've just not required proof of licensure from, I don't know how many years back, all of those need to be reversed and new trials allowed? Is that what you're saying?
Well, I do not think you should get a new trial. If the government didn't prove its case, I'm arguing in this case
Right, no,
that,
I understand.
that it's remand for acquittal, as this court
Excuse me, that's what
I'm sorry, yes.
So that's your view. So how many years back how many cases? We're talking about thousands and thousands of cases?
I don't know the number of cases, and I also don't know whether it's how this court interprets when it occurred, but clearly at least back to Heller, when the court said it is an individual right. But
why isn't Heller a clarification of the law too? Why isn't Heller the same as Bruin?
Well, it was the first time. I mean, can't say for certain how the court will interpret it, but clearly in Heller, the highest court in the land said it is an individual right, and they didn't limit it to just in the home. That's what Bruin said. We are reiterating here what we said in Heller.
Right, I'm just trying to understand where we draw a line. If it's not something new and unexpected, but rather just a clarification of existing law, I think you're asking us to basically, reverse all of those convictions, all these gun cases for the last how many years, right?
Well, I don't know how many of them they didn't present any evidence at all of licensure, like as your honors are aware, in cases they did.
So your argument is Gauss was wrongly decided?
Yes, yes. And getting back to Justice Wendland's initial question, the reason why it's an insufficiency evidence issue is because that's what the Supreme Court has said for decades. In case after case, but Burke's is the most explicit. What the Commonwealth is really asking is saying, look, it's just unfair. We didn't know. And what the court in Burke said, and I just will quote it again, where the double jeopardy clause is applicable, its sweep is absolute. There are no, quote, equities to be balanced, for the clause has declared a constitutional policy based on grounds which are not open to judicial examination.
Can you remind me, was Burke a case where there was an element of the crime that the government was not aware of prior?
No, Burke's, I don't think was.
It wasn't.
Right, I don't know.
I guess I'm wondering, why shouldn't we follow, in this case, the Weems jurisprudence, Harrington, that your opposing counsel cites?
Well,
those cases,
right. Well, I would say that
insufficiency is not the right rubric.
Well, those cases represent one line of thought in the federal circuits, and these are all out of circuits. Again, there is no, and I think it's just, I just want to say this.
I guess taking it on the merits and not dismissing it because it's the Ninth Circuit or the, the 8th Circuit. On the merits, why shouldn't we follow those well-reasoned decisions?
Because I think they're not well-reasoned, and I think that they are not.
Explain why you feel that way.
Yes, well, I'll say this. But I do want to just point out to your honors that none of the cases that the Commonwealth has cited, not one, involved the situation that this court confronted, where there was a post-trial clarification of what the government was constitutionally required to prove, and at trial it failed to meet that proof. Not one single case.
Before you go on, can I ask you to explain why Ellison is not that case?
Because the court specifically stated in Ellison the government's proof at trial met the post-trial clarification of what was constitutionally required. It was not, in the end, an insufficiency of the evidence case. So there hasn't been a case that the Commonwealth has been able to find, not one, where this court reached, where this was the situation and the court allowed the Commonwealth, or the government, to retry the defendant. This would be the first case that any of us could find if you reverse. The reason why I think that they were wrongly decided is because the in a long line of U.S. Supreme Court decisions in many other situations where the courts have confronted situations where defendants got their convictions were acquitted under an error of law situation. The court said, the double jeopardy clause is clear. There is no recourse. And I'm talking about Smith versus United States, Arizona versus Rumsey. I cite several, it might be United States versus Green. These are all situations where it was pretty clear that the defendant, if they had not made errors during the trial, the judge hadn't misconstrued the law, the person would have been found guilty, but the court said, your hands are tied. The double jeopardy clause does not allow this. And I just want to say, the other thing that Burke said is, where the evidence of an offense is insufficient, the only, quote, just remedy available for the appellate court is the direction of a judgment of acquittal. And I understand that the equities in this case, in your Honor's minds, might weigh in favor of the Commonwealth, but you cannot ignore that the equities that are embodied in the double jeopardy clause, that's what the United States Supreme Court said in Green. There are equities that weigh in favor of Mr. Guardado, who would be forced to stand trial again. He's already served his entire sentence, committed sentence. And it was those equities that are embodied, and others, in the double jeopardy clause. And this is what the court in Green said. Thus, it is one of the elemental principles of our criminal law that the government cannot secure a new trial by means of an appeal, even though an acquittal may appear to be erroneous. I think in the cases, so getting back to the federal cases that the government cites there's overwhelming support in the federal circuits for this alternate remedy that this court did not grant, but that is not the case. If you look at the cases carefully, it is clear that the 2nd, the 10th, and the 11th circuits, even in post-trial statutory reinterpretation cases, have held that you do have to look at the sufficiency of the evidence, that double jeopardy does apply. And cases I cited in my reply brief, United States versus Smith and United States versus Mount, are two 10th and 11th circuit cases where the court remanded for acquittal, because there was a post-trial clarification of what the statute required, and the government's proof of trial was later rendered insufficient. There is not this wall of support in the federal circuits as the Commonwealth suggests.
How about, counsel, and I apologize because my memory may be a little bit hazy on this. Didn't the Michigan Supreme Court, wasn't there a state Supreme Court that faced this same issue and said that remand was the right remedy?
Remand for new trial, is that what you're saying?
Trial.
I'm sorry, Your Honor, I'm not familiar with the case, so I can't.
Okay,
I didn't see
thank
it.
you.
The other thing I just want to say is that the Commonwealth cites the case of Commonwealth versus Jefferson, a 2012 case, to make the argument that focusing on what is fair to the government in terms of double jeopardy analysis is something this court has done, but that analysis of Jefferson is it's a misleading representation, I'll just say. When the Commonwealth quotes from the case of Commonwealth versus Jefferson, it excises the language that showed what the court was actually most concerned about was that what happened at trial was unfair to the defendants. This is the antique gun case that the court talks that, and specifically the defendant's ability to present that affirmative defense. And it does quote the language, it does state, as the Commonwealth quoted that language, that remanding for trial would also, in fairness, allow the Commonwealth to submit rebuttal evidence. But
Chief Justice Gantz in that case was balancing the fairness. He basically said it would be unfair to one side and unfair to the other side.
Right, but the concern was that that the defendants had not presented their affirmative defense.
He said had the defendant done that, the Commonwealth would have done this. So let's do
Right.
let's do it again.
Right, let's do it again. But importantly, it was not an insufficiency of the evidence case. Double jeopardy was not an issue. So this suggestion that Jefferson...
No, he said it was a legal requirement that wasn't fleshed out. So we're going to do it again.
Yes, and I just want to be clear, Your Honor,
case.
that this court has never taken the position that when it comes to double jeopardy analysis, fairness to the government is what is at issue. Double jeopardy is a doctrine that's been around since before this country was founded. It's enshrined in our Bill of Rights. It's in our common law. Its purpose, as this court has correctly and consistently upheld, is protecting citizens from repetitive prosecutions by a powerful state. And that is why the law has been so clear. And this is the thing I want to really just emphasize, Your Honors, is that the law is clear today. Beal is clear This court was clear. Munoz is clear. What the Commonwealth is asking is for this kind of fuzzy, wobbly line where it's unfair to the Commonwealth. Well, there's all sorts of situations where the Commonwealth could make the argument that it's unfair. So I understand, as I mentioned, that Your Honors might feel that the Commonwealth was completely blindsided by the holding in Bruin. I don't particularly fully believe that, but even if you accept that, you can imagine other situations where the proverbial writing on the wall was even
The Commonwealth
clearer.
has to follow our guidance, right? So, you know, we've said that you don't need to put it in. So, I mean, the Commonwealth is blindsided. They're following our law. They can't not follow our law, right?
They can introduce evidence of a license when Bruin was on the docket. And, you know, I mean, they can. They don't, their hands weren't tied, that they were not forbidden from doing it, and many district attorneys did. And so I don't, you know, but my point being, Your Honors, is that once you get away from this,
Where's your support for that proposition that many district attorneys did?
that many district attorneys introduced evidence of licensure? Yeah. Well, I mean, I'm sorry, I am aware that other people are in, since Guardado was decided, I'm aware that other people are not in the position that I'm in, that they don't have the, you know, the luxury of the argument that I can make that there was no evidence at all, and of course there is the Bookman decision.
Right.
But in any event, Your Honors, the point I'm making is that this moving away from this very clear line, that this policy that you have always held, that we have to look at whether there was sufficient evidence. Our hands are tied. That's what Burke says. And it is a policy, as Burke said, is that it's not something you get to decide. It's not an available remedy to say we can decide whether or not to impose the Fifth Amendment protection.
Okay, thank you very much.
Thank you.
Attorney Charles.
Good morning, Your Honors. May it please the Court. Assistant District Attorney Jamie Michael Charles for Middlesex on behalf of the Commonwealth.
Can you talk about how you see the double jeopardy clause applying or not applying in this case?
Absolutely. The first thing I just want to say is that the cases my sister just cited for you, that she cites in her brief, Smith, Rumney, Green, those cases concerned a situation where rightly or wrongly at trial, a trial judge acquitted the defendant, and therefore jeopardy attached prior to any appeal, prior to any change in the law on appeal. We have a completely different situation here. At the time that Mr. Guardado was tried, which was a year, excuse me, a year before Bruin was even decided, the law in this Commonwealth, and the law as everyone understood it in the United States, supported the Commonwealth's position that licensure did not have to be proved to prove the offense of 10A, 10H, 10N.
But it turns out the Second Amendment required it. You may not have known, this court may have said otherwise, but it turns out from time, from the beginning of the founding, the Constitution required the Commonwealth to prove lack of licensure.
Well,
how do you respond to that argument by your sister?
Well, I think the first thing I would say is that this court found in Guardado that Bruin announced a new rule and did not apply it retroactively to the beginning of our nation's founding. So from this court's perspective, and my sister and...
Well, let's just assume that it did. The Second Amendment always required this. What is the government's
Let's assume the
position?
Second Amendment always required this proof. Then I would say that the case law the Commonwealth cites is still applicable because we still have a situation where the case was tried under an erroneous view of the law, and the jury instructions that were given to the jury did not accurately reflect what needed to be proved.
And the government didn't prove its case. So why doesn't that require acquittal?
Well, again, if the court wants to accept that this goes back to, if this court wants to invalidate tens of thousands of firearms convictions dating back to Jones, I guess earlier, then I suppose that's what this court will have to do. But I think this court already decided that Bruin announced a new rule, and I think that the vast majority, not I think, the Commonwealth's position is the vast majority of federal case law, and again, I'm submitting a 16L letter to the court today because the Commonwealth found a case from the Sixth Circuit that also reaches a similar conclusion. United States versus Houston, 792 F. 3rd, 663. So 9 of the 12 federal circuits essentially agree with the Commonwealth's position that in this situation where a trial occurred and based on either the fact that the law did not require something or all parties involved in the trial understood that the law did not require something such that the jury were not instructed on that point. 9 of 12 circuits agree that in that circumstance, the appropriate remedy is a remand for a new trial and that it doesn't make sense to apply double jeopardy principles.
Do we have cert requests? Because this is ultimately not going to be our call, right? Because if we got a federal circuit split, you say 9-3 at this point.
I don't mean to suggest it's a circuit split. I don't believe the other 3 circuits have commented on it one way or the other based on the Commonwealth's research. I have not found a single federal circuit that has affirmatively said that in this kind of circumstance, double jeopardy principles should apply. All the federal case law that has quoted Burke's has emphasized that it's a very narrow exception to the general principle that the Commonwealth gets to retry a case where it is overturned on appeal.
And are there any, I take it there's some cert requests in this or not?
If there are, I was attempting to say before that my sister is perfectly, they can take a cert. I'm not aware of it at present in this case, but certainly that is something that the defendant can do if he feels.
I'm talking about out in these other, I'm focused on the federal case law. Because again, we've described Bruin as a new rule, I get it. The U.S. Supreme Court, were they clear or did they leave that vague in their decision?
I don't believe it's as clear as my sister is making it out to be. I unfortunately would have to submit a 16L letter to the court. I don't believe that your honors are the only court that has found that Bruin announced a new rule. And I'd be happy to submit something to the court.
If it wasn't a new rule, there'd be no clairvoyance, right?
I believe that's accurate. And again, well, this court has an interesting waiver doctrine as well that is not necessarily the same.
We get to find non-waiver whenever we want to.
Correct. I think that's astutely stated. But
you weren't so complimentary when you were asking for reconsideration, but we'll continue.
But again, I don't think the Commonwealth is. The Commonwealth acknowledges that the clairvoyance exception determines the standard of review. I'm not saying it creates a substantive right. I'm merely pointing out that, on the one hand, the court is saying the defendant couldn't have possibly objected to this because no one could have known, right? That's exactly what the Reynoso case says in the D.C. Circuit. They said neither the trial judge, the defendant himself, the parties, or the jury understood that this particular element was an element at the time of trial. And therefore, applying double jeopardy is essentially a non sequitur.
How do you distinguish Muniz and Beal?
As the Commonwealth argued in its brief, that was not, I think they're both distinguishable, I'll say at the outset, because they did not involve situations where there was clearly defined precedent of the Commonwealth that dictated what the right outcome was. So in Munoz, all this court did in Munoz was essentially decline to extend 278 Section 7 to the crime of unlicensed operation. There was no prior precedent that's, as there was here with Jones and all these other cases that said, Commonwealth, you do not have to prove that someone is unlicensed to find them guilty of unlicensed operation.
It was just a jury instruction.
It was just an erroneous district court jury instruction. So there was no binding precedent from this court or the appeals court telling the Commonwealth, don't worry about this, just prove the other elements, you're good to go.
All right, what about Beal?
Beal actually, I wish I had flushed this out more in my brief, but seeing how much the defendant focused on it, the Commonwealth dug in a little deeper. There's a variety of reasons that Beal is distinguishable. So first, again, the law was not settled. Based on the Commonwealth's research, there was no prior decision of this court or the appeals court that had affirmatively, explicitly stated that assault and battery is a categorically violent crime under either the force clause or the residual clause. Both Cologne and Eberhardt post-stated the defendant's conviction in Beal. In fact, if you look back in Commonwealth versus Burke in 1983, 390 Mass 480, and then First Circuit precedent, United States v. Harris, 964 F. 2nd, 1234 and 92, that's a decision by Justice Breyer. And 2 months prior to the defendant's conviction in Beal, I don't know why I'm pointing that way, but in the defendant's conviction in Beal, in U.S. v. Holloway, 630 F. 3rd, 252, which was in January of 2011, Massachusetts and the First Circuit recognize that A and B is a crime. Massachusetts A and B is a crime that can be proved in violent and nonviolent ways. And arguably, if you read the Holloway case, they make clear that a certified conviction of A and B would be insufficient under the federal Armed Career Criminal Act, which, as this court recognizes, is essentially identical to the Massachusetts version of that statute. I would also note that in Beal, at trial, at the subsequent offender trial, defense counsel objected to the way the Commonwealth was trying to prove their case. And he cited a 2010 decision of the United States Supreme Court, Johnson versus United States, in which they had interpreted a similar Florida assault and battery law that had both harmful and offensive ways, and determined that that did not categorically qualify under the federal ACCA under the force clause. So there was a variety, so there was no binding Massachusetts precedent that said what the Commonwealth did in Beal was okay. There was First Circuit and Massachusetts precedent that made clear that assault and battery could be proved in a violent way and in a nonviolent way. And there was a Supreme Court case that was decided more than a year before the subsequent offender portion of Beal's trial that found a similar statute in a different state to not qualify under the federal ACCA, which again has been determined to substantially mirror the Mass ACCA. So I would say Beal wasn't remotely the same. I would also just note that having reviewed the parties' briefs in Beal, the only case that was cited by either party was De Benedetto. None of the federal circuit case law, much of which existed at the time that the Commonwealth cites here, was briefed by the courts, was considered by the courts. So while I acknowledge that the court did undertake a sufficiency of the evidence analysis in that case, there really wasn't any sort of drawn-out conversation about should that be happening in the first place. And I think, if you look at the case law here, I'm citing the federal case law because Massachusetts hasn't always reached every question, but the only reason I can't say it's uniform is because I can't find certain circuits that have weighed it one way or the other. But most of the case law that the Commonwealth found is...
What about the cases in counsel's reply brief?
I'm happy to go through and distinguish every case she has cited. I would note that with respect to the Smith case, that appears to be... Now, obviously, circuit courts have more than 3 judges, and they don't always sit on banc. And so there may be differing interpretations of their law. The Commonwealth found a case that postdates the Smith case in the 10th Circuit from 2019, United States versus Arciniega-Zetten, 755 Federal Appendix 835. And in that case, in describing what was said in Wacker, the 10th Circuit said as follows, quote, "We must order the dismissal of any charge that the government failed to prove by sufficient evidence," and here's the important part, "under the law enforced during his trial. But if the government's proof sufficed under the now outdated law, then showing that this proof would not suffice under the supervening law won't win the defendant a dismissal." So that's the 10th Circuit, more than a decade after Smith, reiterating what they said in Wacker, that if you engage in a sufficiency analysis at all, you have to do it under the law as it was at the time of trial. You can't do it on the law that now exists that didn't exist at the time of trial. With respect, I do want to talk about Ellison because I think it's important. I think, with all due respect to my sister, she isolatingly and mistakenly quotes that case. The full quote from that case is as follows, quote, "The basis for setting aside Ellison's conviction is not an insufficiency of the evidence. Rather, we must set aside the verdict because of the erroneous jury instruction. And here's the important part. Under circuit law at the time of trial, the government presented more than sufficient evidence to support a guilty verdict against Ellison. Prior to Free Speech Coalition, the United States Supreme Court that changed the law, it was unnecessary for the government to offer evidence that a minor depicted in a given image was an actual child and not a computer-generated image." So they're saying it's not a sufficiency case because the government's evidence was sufficient at the time of trial. That's why it's not an insufficiency case. Only Free Speech Coalition created that insufficiency. And I think that case is doubly important because my sister tries, in her initial brief, tries to draw this non-existent distinction between statutory changes and constitutional changes. But you can't get much more constitutional than the First Amendment. And Ellison said exactly that where you have a change that's dictated by the Constitution, we're not going to say that that was insufficient where you have to prove something you didn't have to prove before.
Is there a difference in the analysis under our common law double jeopardy, which may not be coextensive with the federal?
I will certainly acknowledge that that Massachusetts can grant more rights to a defendant. I don't believe that Munoz and Beal represent that kind of a difference. I just think they're A, distinguishable, and B, I don't believe this court or the appeals court has ever really drilled down to this degree as to when double jeopardy should apply. So I guess the answer is no. I don't think that the state constitution or this court's jurisprudence grants more rights under the double jeopardy principles.
Either way, it's an open question.
I do, correct. The Commonwealth believes that it is an open question. So again, I just want to reemphasize what some of these courts said. I think the Eighth Circuit said it really well when they note that the Commonwealth is not being given a second bite at the apple. They're merely being given a first opportunity to prove what they did not need to prove before.
With respect to the ramifications of this, if you were to prevail, the defendant under double jeopardy couldn't be sentenced again, correct?
I don't believe he could be sentenced to anything more severe.
He's already served his time for this.
He has served his committed sentence.
Right, so that's a double jeopardy, that's another double jeopardy
Correct.
issue.
He could not.
He has an interest in finality in serving a sentence. He served the sentence.
Correct. The only remaining portion of his sentence is a period of probation that the Commonwealth agreed to stay, as it seems like at a minimum this defendant would be entitled to, is going to receive a new trial on the on the 10A charge in this case and the other associated charges that were affected by Bruin. So, but again, for the Commonwealth's purposes, we're not looking to make the defendant serve more time if he served his time, but whether or not he's convicted is relevant to the repercussions if there are future offenses, as it is in many other cases where we're talking about subsequent offenders and armed career criminals. So if all of these convictions that are affected by Guardado are just deemed to be acquittals, that is going to throw a wrench in many circumstances, or in many cases where these convictions served as predicates for other enhancements, and I don't think that's appropriate where the government didn't know at the time of these trials, and where this court had been telling the government for 45 years, dating back to Jones, and I think it was 76 or thereabouts, and reaffirmed it post-Heller and post-McDonald and Gauss and Harris, that we did not have to prove this, that this was an affirmative defense that had to first be raised by the defendant. And so for all those reasons, the Commonwealth would ask that this court conclude that the appropriate remedy here is a new trial and not acquittal for the affected cases.